Welcome, folks. This is the Joint Legislative Justice Oversight Committee. It is August 28th. This is our second meeting of this summer. Our session, we have up to 6 meetings. So it's the second one, right? And the first thing that we're going to be doing this morning is getting a review from Ben, our legal counsel, Ben Oversight, on the pretrial supervision program. And we will also, at the end of this presentation, along with, we have Judge Zone with us, Terry Corzone from the courts, and Commissioner Demmel, we have someone from DOC, Al Comey. We also have the state's attorney represented here as the Defender General, because they're not scheduled to testify, but I wanted them in the room in case we have any questions pertaining to them. The pretrial supervision program is new. That is a program where someone has been charged and they're placed back in the community with conditions, and DOC will be monitoring those conditions. The decision that we are going to have to make, along with DOC, it's guidance, but along with DOC, there's only about $600,000 that was put in the budget for this particular program to start up. $600,000 is not going to carry it through all 14 counties. So there was language that was put in the bill that it could be rolled out in 1 or 2 counties to see how it starts to work. And this committee, in conjunction with DOC, will make decisions as to where in the state that program will start. So in order to understand how we make a decision, we need to understand what the program is. So we have Ben, that's going to come up, I hope. And then Ben has the PowerPoint presentation. And I don't have this to, we've got that, I can share. Topper,
Yep.
I give this.
It's going to be a minute on the copies.
Yeah, let me give that to the top. Because I think it's really, I know a few of us here know this process of the pretrial supervision and went through the House Corrections and Institutions Committee, and went through the House Judiciary Committee, and went through the Senate Judiciary. So some of us are aware of this, but in order for all of us in the committee to understand what the program is proposed to do, I've asked Ben to put together a PowerPoint to go through the basics of the pretrial supervision, what the structure is and how we carry it out. So Ben, welcome. You're far down the table.
I am. Well, good morning, everybody. For the record, Ben Novodrowski from the Office of Legislative Counsel. It is August 28th. I still refuse to believe that fall is here on Fall's doorstep. So we're still in summer.
The kids are in school.
Yeah, they started.
They are, but still.
Helps your household a little bit.
It does, having a routine, everybody going to the same place. Yes, it's very helpful. But as Chair Emmons said, I'm going to be doing an overview of the new pretrial supervision program, and I'll share my screen to show the PowerPoint that you have before you. So bear with me one moment, please.
We all are out of practice. And if folks have questions as Ben goes along, please ask, because it's going to be really important to understand the pretrial supervision.
So yeah, pretrial supervision program. To start though, just as a reminder and to kind of, I guess, reiterate what Sharon has just said, what the mandate for this committee is today is to review the program and provide recommendations to DOC and eventually the General Assembly on the most prudent use of any funds appropriated to the program and the geographic areas to first implement it. And that's because of the funding shortage essentially for the program, is that there are insufficient funds to roll it out statewide. So this committee's input on where to start would be key to getting it started. And then, as I said, these recommendations are due to DOC by September 1st. So really need to make a decision today, unfortunately. And then to the General Assembly by November 15th. And I believe it was structured that way to basically see if between these recommendations and sort of anything else that happens between now and then, DOC could come back for further guidance from this committee before the recommendations go to the Assembly.
Jenny?
Quick question, trying to remember from appropriations, were these funds, general funds, or so it's not anything to do with the justice reinvestment?
Correct. Yeah, general funds. If I recall correctly, I believe it was 640,000 appropriated to DOC for 5 positions. I could be off, but that's if memory serves.
Okay.
So let's start with the overview of the program. So we're going to have a kind of a quick overview, and then I'll get into details on the later slides. So this is governed by statute, Title 13, Section 7555. It's also the way it operates is that it's imposed as a condition of release by the courts under 13 VSA 7554, A1H and A2G. Only certain defendants are eligible for placement in the program. To be placed, it has to be court ordered. So the court determines whether these eligible participants or defendants are suitable for placement. And then this is DOC administered. So court ordered, but DOC operates it with various supervision levels that are determined by evidence-based screenings conducted by the department. And there's also a compliance and review procedure of those conditions later on to see if they need to be changed, removed, added to, what have you.
So Ben, are you going to go into what determines eligible defendants?
Yes.
Okay.
So again, the governing statutes, as I said, 13 VSA 7554. For those that aren't as familiar, this governs release prior to trial. So anybody that is released, they are either released on their own personal recognizance, so without conditions, or released subject to conditions, and those are outlined in this statute. The court assesses various factors to determine if those conditions need to be imposed. And there are a list of various factors that the court considers in imposing those conditions: risk of flight, seriousness of the offense, the number of offenses. This new condition that was added this year actually is whether there are conditions already imposed for pretrial release, probation, parole, another form of supervision, and various other factors that I'll leave to you to read.
So the key for the pretrial supervision is a person's been charged. They go to an arraignment, and then the court will decide, is bail set? Is bail not set? Is the person going to be detained in a correctional facility? Those are basically the decisions at that point that a court can make.
Right. For the most part, everybody is presumed to be released as of right in Vermont. That's a constitutional right. So it's really an exception to the rule to detain them. So actually a good example of this is that if you read the news over the past few days in Burlington, there was a shooting that the defendant there is being held without bail. That's because she was charged with first-degree murder, which is a violent felony. And that is one of the bases or the exceptions that someone can be held or carries a possible life sentence. So either of those factors can be a reason why someone can be held without bail. But most people are released. Sometimes they don't have bail imposed. They're just released subject to conditions or on their own. So those conditions can be like, for instance, for a DUI, don't drink and drive, don't possess alcohol. Sometimes there's a court mandate to go get a drug and alcohol screening to see if there's a greater issue at play. So those are just an example of some conditions that can be imposed by the court at arraignment or really at any time prior to trial.
So for this particular pretrial supervision, I'm going to kind of help walk through some of the basics because I know some folks here aren't in Judiciary Committee or we're in corrections to know some of the little nuances. So currently, if someone is arraigned, charged and arraigned, and they are released back to the community, the conditions are set by the court. Currently, who supervises that person in the community?
No one.
So that's important to remember, because what this pretrial supervision program is attempting to do is have DOC supervise some of those folks in the community who are not being supervised now. So that's important to remember. That's the goal of this program.
And getting into the program, again, pretrial supervision is a new condition, which is governed by VSA 7555. And the purpose of the program is to assist those who are eligible through the use of those evidence-based conditions of release to coordinate and support the provision of pretrial services when appropriate. So that would be like drug and alcohol screenings to get them help if they need it, to ensure attendance at court appearances, and to decrease the potential to recidivate while awaiting trial. So that is the general purpose of the program. And we'll get into how it really works, unless there are any other questions. Right?
I'll keep my mouth shut. Yeah, you're good.
Well, seeing none, what is the eligibility? Well, it's really simple. There are two bases to be eligible. One, you have to be accused of violating conditions of release pursuant to 13 VSA 7559. That is a criminal charge in and of itself. So if you've violated conditions and the prosecutor deems it necessary to file charges against you, they would do it pursuant to this statute. So if you've been charged, you can be eligible. Or the defendant has at least 5 pending court dockets against them. And a court docket can include many different offenses within it, or can include one. But, this is typically this was the discussion in committee over this eligibility requirement was those real problem offenders, specifically, where they may have 70+ dockets against them for retail theft. So they would be captured as those are eligible. So they can be placed in the program, but there's a further analysis to determine whether they should be. So any questions on the eligibility criteria?
Can I ask a question?
Yeah.
So does somebody make a recommendation to the judge? Because I understood you say the judge makes the determination.
Yeah, so we'll get into it, but basically either party or the court can move to put someone into the program.
Okay.
So what is the procedure? So at arraignment or at a later hearing, a party of the court may move that an eligible defendant be reviewed to determine whether they're placed into the program. The review is scheduled upon receipt of a DOC report containing its recommendations pertaining to the supervision level that's appropriate for the defendant. The court would review the report and schedule a hearing to determine if the person should be placed. But there's that determination is made by assessing whether placement in the program will either reasonably mitigate the person's or reasonably ensure the defendant's appearance in court, reasonably mitigate the risk of flight, or reasonably ensure protection of the public. So that's the determining factor once you're eligible. And there are certain factors that go into that determination. Those factors that the court considers are the nature of the violation of conditions that were charged under 7559, the nature and circumstances of the underlying offense. So if they were charged with retail theft, and then maybe the violation of the condition is don't commit a new crime, and yet they committed another crime. The person's history, prior convictions, history of violence, mental health needs, history of supervision and the risk of flight, any risk or undue burden to third parties or risk to the public safety that may result from placement within the community, and then anything else that's relevant to the determination. So any questions on the initial procedure at the outset once to determine whether someone should be placed once they're eligible? Seeing that.
You'll have some.
So what are the supervision levels that a defendant can be subject to? One, and this is probably considered the lowest level of supervision, that is the DOC's telephonic monitoring system. My understanding is that it's sort of an automated system to remind defendants of court appearances and other important dates. There's also telephonic meetings with a assigned pretrial supervision officer, an in-person meeting with that individual, electronic monitoring, which is its own kind of standalone program that's being operated under the home detention, but is now being brought under this program as another form to supervise someone, or any other means of contact deemed appropriate. So perhaps, Zoom or FaceTime, that could be another form of contact that's appropriate, as determined by DOC and the courts.
So this would be under DOC. And this is what we're gonna have to resolve is those pretrial supervision officers are DOC folks that would be placed in your local P&P offices across the state. So with 640,000, it's not gonna cover 13 or 14 areas. So that's what we'll have to make a decision on. What area would this program start up with? This is all under Department of Corrections. So it puts some pressure on DOC that they haven't experienced before. Now, could they absorb this position in some of the field offices? Possibly. Would they have to hire some folks for other field offices? Possibly. And that's what we'd have to weigh. Hopper?
What's the difference between this position and a probation officer or a parole officer?
Well, that's a good question that I might defer to the department to answer. But from my perspective, I mean, this all happens before sentencing. A probation and parole officer, that's after someone's gone through trial or pled out and they're either set and they're sentenced.
So some of the, and this is what we can get into when testify, some of what we heard in my committee was there could already be someone within the current P&P office, P&P officer that could take this role on. Some other field offices might not have that ability, so they'd have to hire someone. So that's what we'll have to get into when DOC comes up to the table.
So moving on, the compliance and review procedure that I mentioned. So one of the duties of the pretrial supervision officers is to notify the prosecutor and all reasonable efforts to contact the defendant as well of any violations of court-imposed program conditions committed by the defendant. So those would be things that the court orders along with pretrial supervision, that if those conditions are violated, the pretrial supervisor is obligated to inform the prosecutor of those violations. But the officer has a discretion to report department-imposed administrative conditions committed by the defendant. So I think that would be like, for instance, with electronic monitoring, if for whatever reason the electronic monitor wasn't charged properly, I think that would be an example of an administrative condition that may have been violated, but it's discretionary on part of the officer. And my understanding is that the rationale for that, as discussed in committee, is the officer has a relationship with the individual. If it's sort of a one-off thing, maybe they don't report it. But if it's a habitual occurrence, maybe then they have the discretion to report such a violation. And so it gives the officer that discretion based on their knowledge of the defendant. And then also the parties of the court can move for the court to review their conditions, so they can be removed, they can be lessened, or they can be increased.
Quick, short question, because I think maybe DOC will get into it later, and that is what preparation the pretrial officers will be given in order to accomplish this.
As far as the training is concerned, I will defer to the department on that, but there are policies and procedures that need to be developed.
Okay.
And I'll get into that a little bit. And then finally, with compliance and review, the prosecutor has the option also to file the pretrial supervision officer's sworn affidavit with the court to issue an arrest warrant for a defendant who fails to report to the officer altogether, commits multiple violations of supervision requirements, or absconds altogether. So that would be the situation where an arrest warrant can be requested upon submission of the officer's affidavit. And so then there are various policies, procedures, and program support requirements. By the beginning of November of this year, GOC needs to establish written policies and procedures for the program to be used by the department and any of its contractors, but also for the courts to help understand how the program operates as well. DOC must also develop policies and procedures concerning the supervision levels and what the evidence-based criteria is for each level and the means of contact that's appropriate for each supervision level.
Is electronic supervision permissible in this?
Yes.
That might not be the first thing
Mhm.
that they use. It could be just telephone monitoring and say there's violations of that. They're not showing, they're not responding.
No, we said that was.
Right, and
Yeah.
so then it can escalate, I don't want to say escalate, but then the next step could be electronic monitoring. I think the key for electronic monitoring, I think folks will need to ask DOC what they can monitor,
Right.
because that's really important. And I think any type of monitoring of electronic monitoring does not prevent someone from committing a crime.
And
Knows location. It may know alcohol intake possibly, but it does not prevent a person from committing another crime.
Mhm.
That's really important to have that distinction.
And the way this may all work in reality is that let's say they're just imposed that telephonic check-in system is imposed initially. If they just are completely ignoring it,
Mhm.
then those repeated violations may be reported by the prosecutor, by the officer to the prosecutor. The prosecutor may move to the court, okay, we need to review this defendant's conditions because they're not working right now. And so the prosecutor may then ask for an increased level of supervision or not. It's an opportunity for everybody to kind of come together before the court to kind of work out those issues
Okay.
and potentially resolve the case too.
So that was sort of part of my question. So does it envision the court, a court process, a revisiting to change the supervision requirement? So it's not like, okay, well, DOC has these 4 or 5 options available to them, and they can decide which one to use
Right.
based on the circumstances. So the court would order a specific one of those supervision, and then if that needs to change, they have to go back to court.
Correct.
Okay.
And then,
Why do we use the word term, the term may file?
discretionary. So they have the option to for those administrative conditions, but they're obligated to for the court imposed conditions to report them.
So the report had happened,
Very serious looking.
but they may not do the arrest warrant.
Correct. The arrest warrant is really sort of like the ultimate backstop if they're completely ignoring everything and, they have multiple violations, they've left the jurisdiction altogether, or they just won't meet with their supervisor. So that's an option available to the prosecutor, but it's not a requirement.
And currently right now, if someone is being supervised, either they could be on probation, they could be on furlough, even parole. If they're being supervised by DOC, there's discretion there as well from that field officer, from that P&P officer, whether to bring that back to the court, bring it back to DOC, or bring it back to the parole board. Because they build relationships with the folks that they're supervising, so they could tell if, oh, this is a one-off, or it's a perpetuation of a continued violation of conditions. So it does, right now, there is discretion.
And within the committee discussion, there was a lot of talk about striking that balance of accountability, but also not overloading prosecutors, not overloading the courts, where the prosecutor would have to, and DOC, where DOC would have to report every little violation to the prosecutor. So, you know, there was that balance to give some discretion to perhaps the more minor infractions, but then obligated the reporting of the court imposed ones. And then finally, the program is contingent on funding, so if it's not funded, the courts cannot order it as a condition of release, and DOC can engage with any public entity to help with its operations of the program. So perhaps a local sheriff's department or a state corrections department. So again, as a reminder, the committee's task is to make recommendations on the use of funds and the areas for the program to first be brought on board. So with that, I'll take any questions. Any other questions?
Easy.
Yeah,
Yes, for Ben?
I just.
Yeah.
Just had a quick one, Ben.
Yeah.
When you talked about the monitoring of these individuals, I believe in Senate Judiciary, there was a bit of a concern about someone other than DOC doing the monitoring and a not-for-profit entity monitoring the system. I didn't see that on there. Has that changed? Has that been
So
tweaked?
that was taken out during the legislative process. That I believe that there was testimony. I want to say it was in the House that no one knew of any nonprofit entity that engages in this type of work. So they were struck. That option or ability for a nonprofit was struck altogether.
But there could be another entity, like the sheriff's department, but we haven't,
Correct.
none of that has come to fruition.
Yeah, the full discussion was, you know, the private entities wanted to be excluded from sort of the profiting concern with that. So a public entity was what was settled on.
So for the next part of the testimony, I'm going to leave this up to the committee. Do you want to hear from the courts or do you want to hear from DOC first? Does it matter?
So I have a question. I mean, how much does it matter as far as the court ability to address these things as opposed to DOC as far as determining where this should happen?
That's what we need to determine.
Right. So I think we need to hear from both, but probably
do.
DOC first. Yeah, but I mean, just, yeah, to understand the capacity of the court to deal with this issue in a particular county.
But we have them both scheduled. I'm just saying, where would the committee like to go next? To the courts or DOC?
I'd say DOC.
I go for DOC.
Okay.
I vote for that too.
Thank you, Ben.
Pleasure.
So I don't know from DOC. Al, are you coming up as the commissioner? Welcome.
Morning.
Morning. You're on the hot seat.
For the record, Al, our Chief of Operations with the Department of Corrections.
So you heard some of the questioning.
Yes.
Do you have any documents? Is this the only
There's a
document?
policy that was in the last night. I think Haley has it on slide deck that she's going to share here in a minute on the screen for folks to see. It's in her packet.
So as what Ben stated, in order for this to occur within DOC, one of the processes for DOC, they have a lot of policies and procedures. And this is all done internally within the department to carry out initiatives or procedures that the department carries out. And they have a whole slew of policies, procedures for everything that they do. So this is new.
Just, you know, yeah.
And it was put out, has it been formally adopted?
It has not.
Okay.
We wanted to share this draft with the committee before we move forward with any implementation efforts. As we discussed earlier, we need to determine the site for this, the pilot site, understanding that the funding that was allocated for us is not enough to implement this statewide. The 5 positions that we were allocated, while we have been authorized those positions, we've not seen those positions yet. Those are still in classification with the Department of Human Resources. I don't have a timeline on when we may receive those positions, hopefully by the end of the year, but before we do have those positions, we won't be able to move forward. We've been working closely with our Newport Probation and Parole Office as the potential pilot site for this program, utilizing both Essex and Orleans counties. We have a very good relationship in the Essex and Orleans area with the AGO's pretrial monitoring program. We work closely with them. We've been discussing kind of a handoff with that program to ensure that we're not duplicating services, that there's a smooth handoff of services. The pretrial monitoring is more recommendation and volunteer, where this would be a mandated program. We've worked closely with the Vermont Department of Health, Division of Substance Use, on referrals for designated agencies and treatment providers within the Essex and Orleans area for any treatment opportunities that or conditions that may be imposed by the court or the local P&P office. So there's been a lot of work going on in the background in coordination with developing this policy with our internal group.
So given that there's insufficient funds to implement this statewide, and you talked about working with Newport, are there any other places in the state that you would prioritize for inclusion in, what might be a pilot?
I think if we were to expand, I would look at Caledonia County initially, just to kind of keep it in that general area. As the chair stated, this is new for us. We've not historically done anything pretrial. We're great at supervision, but pretrial supervision is a different program for us. And nationally, state agencies of corrections don't do pretrial. Those are locally operated by courts and counties. And where we don't have the county system, where this puts us in a new realm for us. So part of the question, I think one of the other questions was on what is the training component and the title. Our intent is to use probation and parole officers. It's an existing job class. We wouldn't have to create a new job class. They're familiar with risk assessments, their referral processes to treatment providers. They know the work. We just don't have the statutory authority for return to custody, arrest, and so forth. But the report writing and the risk assessments that we use, those staff are very familiar with that already.
So, I mean, in the enacting legislation, it, used the term first implement. So it seemed to indicate that it wasn't necessarily intent to be able to do it statewide in the first year.
Right.
And so is it the department's recommendation that we contain it? It sounds like what you're saying is to contain it within the Northeast Kingdom.
Yes, our proposal is to utilize the Newport Probation and Parole Office with both the Essex and Orleans County courts to start this program for us to kind of get it off the ground and work out the pain points and push this forward so that we can be successful with it.
So I'm thinking about the folks who would be put into the program, who are the pretrial, and what data do we have from that part of the state? So what types of crimes are you looking at, or frequency of crimes are you looking at in that area that really sort of provides the evidence to contain it to the Newport, Essex, Orleans area?
So our staff in that office have worked closely with Judge Tebow up there, the state's attorney's office. They've reviewed the cases. It's a smaller number, certainly. It's a smaller court. But we're seeing, initially 10 to 12 cases to start this off that would be eligible.
Are these retail theft cases?
I don't know the charges
No.
off the top of my head.
Okay.
I could get that information, but
I'm just trying to sort out what are the most predominant types of cases and violations that might suggest that we use this to lower that number.
what we've looked at is the criteria outlined in the legislative language is around the five or more
Yeah,
charges or violation of conditions, existing violation of conditions.
okay. And then my other question is with regard to the use of probation and parole officers. You say it'll be only 10 or 12 cases that would be assigned. And I do understand that some of our probation and parole officers are oversubscribed. The caseload is huge. So adding 10 or 12 in an area where there are fewer offers an opportunity to look at how probation and parole officers do with this new educational piece. Does it give us, demonstrate what would happen if we had to hire someone new up front to do the work? So will it give us that information going forward?
Yes, I mean, we're statutorily mandated on our caseload sizes. So with the current existing PMP officers, and those caseloads are statutorily limited. So we understand that. We know we don't want to burden the existing staff with an additional program that's outside of the realm of the normal work. But I think to your question is like, how do we measure that is.
How do we measure it, and how do we measure it against someone who comes into the program new, a new supervisor? And how do we know that that can be effective, and who we hire for that?
Well, I think to my earlier point with the work that we do, I mean, we do know supervision and we know the risk assessments, we know the interaction, we know how to communicate effectively. We have existing relationships with the courts and with the state's attorneys and the public defenders in those areas. And it's building upon those relationships with the new staff as well and bringing them into the office, setting them up for success, just like we would set up the individuals that we're supervising for success, hopefully. But the training components all revolve around the assessments that we would use, we'll see.
I saw the Ohio assessment.
Yes, the Ohio risk assessment screens, yes. There's a pretrial component, but we use that normally for our population now, but there's a specific pretrial assessment tool that we would implement as part of this program. Some of the discussions we've had with our internal committee is around like a focus group, like nobody that's on an area where there is no pretrial and an area where there is, and comparing the cases around success rates. Before we expanded that statewide to see, is it really that effective? Because we don't know. And that's something that we're discussing internally at this point.
So Al, within the PMP office up there in the Newport area, are you going to absorb this? Is the proposal to absorb it with your current staff there, or are you going to have to hire someone?
We would hire somebody.
Would it be one person?
One person at this point, yes.
And what other costs would be involved with this? For
So-
DOC
A lot of it,
in that area?
The staffing costs, obviously, the salary and benefits is a big piece, which is where the 5 positions and the 640,000 are allocated. Leaves very little room for anything additional, which could be the cost associated with additional electronic monitoring, the telephone monitoring. We do have a meeting today with Fieldware, which is the company that provides the telephone monitoring software. They have expanded capabilities and technologies now with cell phone check-ins. I know that Ben had talked about, potentially FaceTime, Zoom. So check-ins through text messages, through location sharing with the cell phone and increased monitoring efforts there. So we'll be talking with them today. But the initial cost, I think it's really the salary and benefit component of it and any potential increase in the electronic monitoring fees. Should we expand this and we see an increased number, those costs could increase with the need for an additional vehicle for staff for field supervision purposes, equipment for the new staff, laptops, computer, uniform, anything like that. But that's where we would be looking at the cost at this point.
Do you have a budget?
We have we submitted a budget early in the legislative session last year on what the cost would be to implement that statewide, and that is broken down. On
Same one.
yes.
So there's a 600,000 plus, so what you're proposing for just this one area would not use up all of the six.
It certainly would not, and that would give us the room for expansion should we need to roll that out or into the representative's question on where would the next potential area be. It's really the staffing costs at this point, because we would have to have the staff to do that.
So maybe the question before us, do we just recommend just one place, which would be the Newport?
Mhm.
Or knowing that there's 5 positions that have been approved, though they haven't come online, they've been allocated, but they haven't come online. The money is in the budget for FY 25. Do we, what's before the committee, I would think, do we just start with one out of the Newport? Or do we make a recommendation and say, start up with 2? Right off. That's what is before us, that we could make a recommendation.
So I just have a question and whether the charged individuals, the people who will be dealt with in the Northeast Kingdom and Essex and Orleans, are they comparable? Do they have the comparable issues as those in more, I don't think I'd call any place metropolitan in Vermont, but
Chittenden County?
yeah, in Chittenden County or
Rutland
Rutland, those areas. I mean, are they facing the same issues? So are we going to really learn how well this is working or might work for Rutland or Burlington by what's going on there?
Yeah, I think we are seeing a lot of the same issues in those areas across the state and within each of our probation and parole offices. And I think one of the things that really hinders the people showing up to court is transportation. And that's something that we can, work with those folks on, is like connecting them with RCT to get to court. And areas like that. It's about helping these people succeed, right? We talked about the purpose and the intent is the intent a stick or a carrot? We're hoping it's more of a carrot to encourage the folks to get to court, to be there to assist them in finding resources, to give them what they need to show up for court and be successful in that. So I think to that point, and then a lot of the charges we see in those areas are very similar with drug-related crimes, assaults, aggravated assault. I mean, that kind of criminal history.
Just related to Martin's question. So on a per capita basis, the Northeast Kingdom is high in terms of substance use and substance use crimes. It also makes me wonder about, to what extent will these staff positions be able to assist individuals in connecting, for instance, with treatment or with, follow-up services like, you mentioned the designated agencies and mental health supports. And, I hesitate to call them case managers or service coordinators, but lots of times that's kind of what these folks really need in terms of somebody who's going to be there kind of on an ongoing basis.
Yeah, and that's part of our intent in creating these positions and the work and a smaller caseload is to ensure that those services are available. Our work with DSU has started, those discussions and those partnerships. We work closely with them in all of our state buildings, but specifically for this pilot in Newport and looking at what resources are available so that we've got the relationship with DSU and the service providers that they have in that area to ensure that those connections are made.
Yeah. And as I think as we sort of move through this and think about this, one of the things we might think about is whether there would be benefit in allocating maybe at least one of those positions as a service coordinator or case manager type of position. Is sometimes there might be a difference of approach between a probation and parole officer and just even the title.
Yeah, right.
And thinking about somebody who might have a different role in that, and maybe one of those positions might be beneficial in thinking about it from that. But I realize this is all just getting started, And certainly we don't want to replicate things that already exist, but you know, I know.
And that's, sorry.
Yeah, I was just gonna say, but I know both in the DSU system, in the substance use system and in the mental health systems, they're lacking in staff as well.
There's
So,
that, yes.
yeah.
And that's, you know, we've had those conversations. We've also had pretty in-depth conversations with the pretrial monitoring program. And again, to not duplicate services, but to ensure a handoff and help that team succeed as well. You know, I think in our conversations with them, a lot of their frustration is they haven't had the accountability tool
Mhm.
where we will be able to provide that and hopefully see greater success.
Mhm.
But I think even though the title, the working title, probation and parole officer, it's just easier from a classification standpoint, not having to create an additional
Mhm.
position through that process. But the training component and the work is certainly different. And the work of a probation and parole officer is certainly different than it was 15 years ago when I was a probation and parole officer. And it really is more about the service oriented work and finding people doing things good, not finding them doing things bad, and helping them succeed. So that's really the goal with these staff in this program.
Martin, Jenny, and then Maria.
So I guess I'd like to see the conversation change a little bit from the concept of pilot, which I don't think the legislation actually says pilot. It does say it's subject to the amount of money. I mean, I would like to understand or see what a rollout plan is. And if Essex and Orleans is the first step, great. But rather than having to revisit to see how it's working, let's assume that we've got our ducks in a row. And what is the rollout? What's the next stage for this? Which will also help, presumably, in any budget request to start gearing it up for fiscal year 26. That would be, I don't know if that's something folks have considered, if you have a rollout plan, and if not, you know, if that's something that could be doable.
It's certainly something we can do. We do not have one at this point. I mean, our focus has been on standing up the small program in the Newport area. But we can certainly go back to the office and start working on a rollout plan and see where it would fit best across the state and what that would look like.
Right, and that could take advantage of what we already have in the budget for that next step, hopefully happening in 25. So.
Yeah, we can certainly do that.
Yeah, I guess that's similar to the question or the comment I was going to make. It would be helpful to know how this is all going to work. And maybe when we go through this, we'll get an idea of it. This is an outline
Right.
thinking.
The draft policy.
Yeah, so it's just draft. And going back to your questions that you've indicated that Newport demonstrates very similar crimes and pretrial issues with other parts of the state, including more populated parts of the states like Rutland, Brattleboro, Burlington. So it would be helpful to understand how this program is going to roll out to support folks in those areas, with or without transportation. I think we all know transportation is ungodly in the rural parts of the state, but so maybe it would be good to.
We can start, we can go through the policy and then probably answer some of those questions.
We have one more question, Irene.
Thank you, Madam Chair. I wrote down 5 people, salary and benefits is, I guess, that's $600,000+ would cover. And then I heard the chair speak about 1 or 2 people, and I'm just wondering if 1 or 2 people can cover the 24/7 monitoring, or is it not 24/7? And I'm just trying to reconcile those numbers.
You mean the electronic monitoring or?
The supervision in general, I'm not.
Yeah. So it would not, it's not 24/7.
It's not, okay.
Obviously, we are a 24/7 agency, and should something come to our attention in the middle of the night, we would certainly respond, but it's not an active monitoring system. And we have capabilities of active and passive. We choose the passive monitoring component where staff come in the next day and look at the data and waypoints where somebody may have been and so forth. But it goes to the earlier discussion that it's not an immediate response to violation behavior. It would be a day after the fact, 24 to 48 hours, depending on when we see that data. Even the telephone monitoring system, it's calling and leaving a voicemail, basically there's canned questions that are asked that would be relative to pretrial supervision that we would develop with the provider. Those questions would be, have you made your court date? Have you talked with your attorney? Have you engaged in treatment? And yes, no questions, and then we filter through those and monitor those. So that's what that would look like.
So are you okay with one or two people, or is five ideal, but you don't know?
Well, I think,
Five people.
I think five as we expand the program, but I think to start, we would be, I think, we feel that we can do this with a person in Newport at this time. And then expand from there, and I get to the earlier question about the rollout plan. We could certainly highlight a lot of that in that plan.
Chopper?
Help me understand something. Because as I listen, all I'm thinking about is an existing parole officer. You're planning to hire somebody new in Newport, is that correct?
Yes,
Okay. And that person's going to be trained.
yes.
Now, what is in here it talks about a parole officer or a probation officer. What's the difference between those two?
There is
The new person you're going to hire and somebody that's there.
So it's a training component, right? And I think if we go to the working title of the position, we have a position title that's,
So you're going to have a different job description for this person.
the working title would be different than the actual, we're gonna hire a probation and parole officer because it's an existing job class within the DHR classification
Okay.
system. Pay rate comparable to all the other PPOs that we have. Working title would be pretrial supervision officer.
And they're going to be doing different things
Yes,
than a probation parole officer would do.
very similar, but different in regards to risk assessments, referrals to programs, to treatment, accountability, phone calls, the office visits. They're very similar work, but without the statutory authority to return somebody to custody should they be violating their conditions.
Okay. Would you hire somebody that's already in the office?
Potentially,
Probation parole officer?
potentially.
And then the new person that you hire would take that other person's job?
Well, if we.
I'm trying to figure out how this thing is gonna work in the local office.
Yeah, so we would recruit a new position. If it's somebody that's interested, if it's a current probation and parole officer that would be interested in doing this kind of work, they could be a fresh college graduate.
Yeah.
Human services background, this is right up their alley. We would certainly consider that person, and then we would fill for the probation and parole officer, we would recruit for that. We recruit pretty consistently across the state with those positions. And if it's a backfill position where we would take from the local office
Okay.
for this role, then we would hire for the specific probation and parole officer.
So that's a good segue into, Al, if you could just quickly go through what is being proposed for your policy.
So the policy really is an overview of how we would implement in the department a pretrial supervision program. The second page 2 talks about the referral process. Ben kind of touched on this in his presentation around the eligibility for the violation of conditions or 5 or more pending court dockets. Additional criteria that we would be looking for, that the person would have to be a resident of Vermont with a Vermont address. Otherwise, we wouldn't be able to supervise somebody in another state or jurisdiction. There's no detainers, warrants, or holds. That would require the individual to be incarcerated. It's not currently under any form of community supervision. That the services would be redundant as we're already supervising the person and would hopefully already be aware of any pending charges. And that they have the ability to make phone calls to the telephone reporting system. And the ability to report to the office when required to do so. If they don't meet that criteria after the referral from the court, then we would notify the court as part of our reporting structure. that they would not be eligible to participate. If they meet the criteria, we conduct the Ohio risk assessment, the pretrial supervision. You'll see on page 3, there's a graph based on the Ohio risk assessment. So we've got the offense level, whether nonviolent.
Quick question on page 2.
Yep.
I apologize. So I guess I'm troubled and I understand the way this is set up with telephone recording and the like, but individuals who are homeless and don't have access to a phone, from my understanding, often can be the folks that probably need the most help in complying. And if there can be consideration, maybe not initially, but of how that population can be served with the supervision program.
Yeah, we can certainly look at that, see if there are any programs, maybe through economic services that provide phone or something like that.
Right, thanks.
I've got a quick question.
Oh.
Yes, if you can just back up to page 1. Sorry, but I hear this all the time. I just need you to elaborate briefly on using evidence-based strategy. Can you elaborate on that a little bit?
So evidence-based strategies would be utilizing data and successful program information from other areas. So like myself and one of the supervisors from Newport attended a training seminar in Indiana with Indiana County that's doing pretrial supervision and their success rate and how they've implemented that program to reduce their jail incarceration of detainees, success rate. So those are models that we're looking at where there's evidence there that shows this program has been successful in another area. And we can take that evidence that they've provided us and incorporate it into our practices.
Okay, thank you.
Yeah. Go back to the grid, I think. Any other questions before the grid? So you'll see here, we have 3 levels of supervision.
Just quickly, sorry to do this to you. Going back to page 2, where you have really put in place as an outline, assigned probation and parole officers. So it becomes fait accompli that regardless of where this is in the state, we'll be starting out with probation and parole officers. Why not also have a phrase in there that says, or other trained supervisor? So that going forward, there are options for folks regardless of where they are.
I think we can look at that working title
Yeah, okay.
component of it where.
Just to make it more consistent.
Yeah. Yeah, we would reference our supervision officers. So the grid, we have 3 levels of supervision, level 1, 2, and 3. Those are based on both the score of the ORAS and the charge that the individual is pending. So non-violent misdemeanor with a high risk score would be at level 2. Unfortunately, the supervision levels are further down. Where are we? Page 5. You can see the supervision level is highlighted in section C. Individuals with a level of 1 will be monitored through the telephone reporting system. Individuals with level 2 will be monitored through the telephone system, and 2 calls from there assigned supervising officer per month. And then level 3 would be the telephone reporting, 1 call from the PO per week, and 1 required in-person office visit per month.
Well, for the risk level, does that look at the severity of the crime as well as the risk? And
Yes, that's all part of the risk assessment tool.
Also include the risk of not showing up or flight.
Risk of flight, criminal history, yep, that's all taken into account as part of the assessment tool. And we can certainly share that tool with the committee if you'd like to see that too.
Then you really get in the weeds.
Yeah.
Robert?
So if, I'm on the other end of the phone and I'm in the pre-trial situation. And you would ask me, did you go see the doctor today? And I'd say, yes. How was that visit? Very good. I loved it. It's great. Does anybody check to see if I went to the doctor? How do you do that?
Well, I mean, there would need to be releases in place. And I mean, I, depending on the situation, if we said substance abuse counselor instead of medical doctor, right? Maybe it's a substance abuse issue that we're looking at.
Yeah.
Then we would have part of the intake with this individual, release of information signed from a treatment provider that they may be engaged with. And then we would have that ability to talk with that person to say, you know, we just want to make sure, verify that this person's showing up, and with that release, we would be able
You
to.
do that?
Yeah.
And that's going to be part of the training
Yeah.
for the new
Yeah,
person.
and our POs do that now.
Okay.
They do, yeah.
So Al, that raises a question that I've been hesitant to ask about this. HIPAA
Yes.
has popped its ugly head up in some places, particularly in my community.
Mhm.
Because we're be working with our other providers there to release information. But it is up to the defendant to voluntarily sign
Correct.
those release of information forms. So if that doesn't get done, information cannot be released
Correct.
back and forth. How often does that occur?
It's rare, honestly. I mean,
That the release of information forms are not
they're
signed?
not signed, yes.
Because that's an issue that
It-
percolates out there.
It is, and if that was something that occurred with this, we would certainly refer that back to the court, saying that we're unable to verify their compliance with program requirements,
So that person wouldn't be eligible, right?
potentially not, right?
Okay.
So let's go back to page 3 here.
Mhm.
And why don't you walk us quickly through?
So this is the referral and the report. So we would determine the eligibility, risk assessment, who would be completed. DOC would have 10 days to, within 10 days of the receipt of the referral, the report will be returned to the court with a recommendation of whether the candidate is appropriate, that they meet the criteria in subsection 2 of this section. If the defendant does not meet the criteria, we would not recommend them, and the reasons why they would not be recommended, whether that's their refusal to sign a release form, whether they're, you know, risk of flight, whatever it could potentially be, not a resident of Vermont. We would include the supervision level. Part of this in here, the request for the assigned PPO to be named a party of the case. This is so that we could get the updates from the court system on new court dates, any changes, any status conferences that are scheduled and so forth, that the PPO is aware of that.
So you wouldn't automatically receive that unless you were party to the case?
Correct.
Is that gonna, being party to the case, having that probation officer being named party to the case, is that gonna give that officer more authority or control than they would normally have?
Not so much authority or control, but information, just the knowledge of when somebody should be reporting to court, any change that allows them to make a phone call to say to the individual, hey, your change of plea was changed, or, you know, you have a status conference scheduled. Just want to make sure you got that information so that you can show up. It's really sharing, being informed so that we can share that. And again, part of the ensuring success in the program.
Do your usual PMP officers party, are they usually parties to the?
It depends on the case, not initially, because they're not under our care and custody. Violation of condition or, a violation of probation, they could potentially be named in that, and be updated on that information. But that would be a question for the judiciary on the best way to do that.
They're thinking.
So then part of the report would go into recommended conditions of supervision, including any change in residence, the reporting is directed, complying with the telephone monitoring. We then go into the intake process, what that would look like, which is no different than a normal intake at any of our field sites. Face sheet, photograph, get the individual entered into our offender management system. Review the court orders, conditions of supervision, any agreements as required by the court. Orientation to ADA. Information around the local office and who to contact in case of emergency. Creating all that documentation.
So what you've listed out here in 1 and 2 is what currently occurs when someone is being
That's
supervised
an intake.
as an intake.
Yes,
This is tracks.
pretty standard, yeah.
Is there any addition here that would not be in the normal intake that you do now?
No. Pretty similar across the board.
So is there anything about maybe I just didn't see it, about medical status or somebody's on
MAT.
thank you. Yeah.
Well, that would be part of the intake. I mean, part of the questions that we would normally ask. This is a very broad overview, but we would get into that, like treatment providers, if they're taking any medication. Talk about the release. That's something we can certainly add in there if needed, but part of the regular intake.
On page 5, we did go over C,
Mhm.
and then we have D, E, and F.
Yeah, so the case reviews, the
Just before you move off from C, so I remember us talking about this earlier and just was wondering if you were going to suggest or modify this to include video conferencing.
Mhm.
Yeah,
if that technology becomes available to us after, we would certainly add that in there.
well, it seems like it could be an or.
Yeah, we can. On D, we move into the case review. The PPO will review the case every 90 days, provide an update to the court on that review regarding the defendant's compliance or lack thereof. If they are compliant with the program, we can consider removing them from the pretrial supervision program or lowering the defendant's level of supervision depending on their compliance with the conditions that had been imposed. If we're seeing somebody that is successful and does not need the hand holding or, the push to get them where they need to be, is registering compliance with us, we would make that recommendation that they may no longer need to be on supervision before their case. Again, moving on to the violation behavior, if there's any condition violated, we would notify the court of that violation. Court and state's attorneys submit the sworn affidavit. All back to the respondent. Then the completion component is that they've been removed by the court, been sentenced on all dockets associated with the trial, or have had their supervision revoked by the court.
So this is an internal policies and procedures in the Department of DOC. What is the public process? You said this is the first draft.
Mhm.
It has not been approved by DOC.
Right.
Is there a public process between now and when DOC signs off?
We do have a public comment period. We have an internal comment period. We have shared this with the judiciary. I know that Judge Doning has seen this policy. So yeah, we're ready to move that forward and be ready to go for the November 1st or what date.
And how would the average public or organizations know that this was being proposed and there was time for public comment?
It's on our website.
So people would have to go to the website, have to know to go to the website. Questions? That's,
I won't raise the whole internal issue and lack of regulation. That process.
So overall, it looks like it's a good start. And it'll help folks move ahead, help you move ahead a little bit. I do have some comments to make as you're going forward with more detailed policy and process.
Mhm.
And so first of all, the comment earlier about ensuring it's not just probation and parole officer, trying to think statewide, it's a supervisor, could be somebody new. And then what's the goal of this? The goal is to keep folks in the pretrial environment from committing another crime and staying out of DOC, staying out of the judiciary. So as the educational piece goes forward, it will be important to have something in that helps the supervisor provide information for the individual who's been charged to keep them from committing another crime. And then, or meeting their court dates or whatever it is. So a supportive environment. So everything that's here is making sure that they adhere to the requirements, but also to have that supportive environment going forward. So the educational piece for the supervisor will be key. And I think our probation and parole officers probably understand that. And then the minor detail, the contact versus the call.
Mhm.
If you're thinking of providing a cell phone for folks and it works to have the call, but if not, then somehow, I think someone else brought that up earlier, but I'm just trying to. So I look forward to the more detailed information and hearing from the courts, their thoughts as well.
Thank you.
so we do have a question on Zoom, Nodder, and then Topper. Let's go to Nodder first. Welcome, Nodder.
Hi, sorry I wasn't able to make it there in person today. And also I apologize for missing the first 45 minutes or so of the meeting, but I do have one question about the violations, and perhaps this was covered at the very beginning, so I apologize if it was, but if someone were to violate a condition of their supervision, I mean, what would the result be for them? I mean, would it be comparable to a violation of probation, or, I mean, is it something different? That I was wondering if I could get some more clarity on that.
I think that would be at the discretion of the court and the state's attorney. We would make the referral for violation behavior, but we would not impose the violation. I would anticipate it would probably be a violation of conditions of release, depending on what the behavior is.
Thank you.
Topper?
Just following up on Senator's comments. I think it's important that you distinguish between what this person is and what the probation and parole officer is. Because I'm okay with it now, I understand, but I don't think general public or maybe people in the office might not know.
Yeah,
Because it's, at least when I read this, it's tied to probation and parole. And it's something entirely different from that.
because they're not sentenced.
Yeah.
Correct.
But you could have, depending on the caseload, depending on the staff of the particular field office, wherever that may be, regardless of how we first roll it out, if it becomes statewide, at some point, you could have a P&P officer take this role on as well,
Potentially,
correct?
potentially.
It just would be the training and what is the difference there.
Correct.
And I heard you refer to a working title
Yes.
as well, which sort of like, you know, I get what he's talking about, rather than creating a whole new class, and then that takes a lot longer. and All of that kind of stuff. So, you know, working titles within the office will say something.
Yeah, and we can certainly adjust that within this document.
And we specifically worked on what to call the folks, and it's the pretrial supervision officer, you know, making it distinguishable from the role of probation officer, so.
Any other questions from for DOC before we move on here? Thank you, Al.
Thank you.
I know that we have Tim Dumont here for State's Attorney. I know you have to leave at 11:30. Is there anything you want to share with us at all, or you're good to go? That's the same with the Defender General when we get to that point.
Well, then I'm gonna,
Judge O'May, do you want to come up?
sure. Should be available. I do.
Make sure there wasn't press.
Good morning. Tom Zone, Chief Superior Judge. So as far as the court's position, I know that DOC has included the judges who would be affected, and that would be the Orleans and the Essex judge. And so Judge Tebow, as well as Judge Kane, were involved with the DOC representatives throughout the process of discussing what would it possibly look like in that area and how to be implemented. This includes review and input into the policy that DOC has provided to the committee here today. As far as the court's position, the legislature has enacted a statute that requires DOC to go forward with its pretrial supervision program. What DOC has put together so far is in furtherance of that. And where they've included us, we will do what we need to do to make it succeed for what the court can offer. Senator Lyons asked the question early on about the types of cases. Well, as Ben explained at the introduction today on the statute, there's two ways that you can get into the program. One is if you have a violation of conditions of release, which can be a single charge, as well as if you have 5 or more separate dockets open. If I did my math right, currently there are 1,549 cases pending in Orleans County. It looks like 912 of those involve violations of conditions. Of the 912, 329 involve 5 or more cases for 33 defendants. And so basically, you have quite a few individuals who would qualify sitting here today for this program. So when I hear the number 12, as 12 people coming in, you have a significant larger number of people who may qualify and may benefit from the program. In terms of how the program would go forward, the court would make the time to be able to handle it, because this does add to the court an obligation. Once there's a request made for the review, we then, when we receive the report from the Department of Corrections, have to have a hearing. That's a hearing that does not currently exist, nor is it a hearing that the court would normally schedule in a case. And so that's another hearing that we have to hold. Ideally, by holding that hearing and putting an individual into the program, if that's the decision, will mitigate the potential for further hearings on violations of conditions or other criminal conduct that could be alleged. And so my thought is that by doing this program, yes, it adds something to what we need to do as far as court hearings and procedures, but also the net benefit will hopefully be reducing another level of what's coming in, so that we don't have that 912 number for VCRs, and that is significantly less in the future. And Senator Hashim asked a question about what happens when there's a violation. The way that this is structured has been explained is the legislature this past session amended 13 VSA section 7554, and that's the statute on conditions of release. It added a provision in there that as a condition of release, the court has the ability to
put someone in this program, the pretrial supervision program. Accordingly, if someone violates it, the potential under the way the program is put together in the statute would be that the state's attorney is notified. The state's attorney then would have the option of whether or not that the state is going to file a violation of conditions. And then once that's filed, the court would have to determine if it does meet the criteria to establish a violation of conditions. So I'd be happy to answer any questions that members of the committee may have.
So you answered one of my questions, Judge. Thank you, that I was thinking about in terms of like what's the universe of potentially eligible individuals, and what would the caseload potentially look like? And so I guess one of the questions that I have is that I can foresee that, whether it's defense attorneys or the individual themselves or the Department of Corrections or whatever, I can see that there is the potential to exceed the capacity in relatively short order of the ability to handle the number of cases that potentially could come in under this element of sentence, or not sentencing, pretrial. And what are your thoughts about, so the concern I'm trying to get to is, then it seems as though if there's insufficient resources to be able to meet the demand, then it sort of sets up an equity issue even before you get to trial, because not necessarily all individuals might not have access to something that resources that, I guess should be available to anybody who meets the qualifications.
Senator Sears used to always talk about geographic justice.
Yeah.
And this actually, what we're talking here today, you're talking about it, it's referred to as a pilot project, but that's not what the statute said. The statute said it was for everywhere. And so I think like with many statutes, there may be times where a certain geographic area gets something that other areas don't, because that's just necessary. And in doing that, you look at it from a need perspective and the ability of the stakeholders to have the resources to achieve success there. And so DOC came up with the idea that the best place to start this, as I understand it, would be the Newport area. When we now zero in a little bit further, yes, there will be individuals who would possibly benefit from this program that won't be able to get in it right away. And I think Al mentioned that Judge Tebow, who is the presiding criminal judge there, has been part of these discussions. And for instance, as we're sitting here now, I have in front of me a chart of every defendant who has 5 or more cases in Orleans County. And Judge Tebow, I know, reviews these charts. And so Judge Tebow, state's attorney, the defense bar would have the opportunity to look and say, who's going to benefit the most? And so, yes, there may be difficult choices initially, and ideally we get to a point where we're able to expand it, whether it's just in Orleans County, Essex County, or throughout the state, to address those types of issues. But initially, yes, there will be areas that by necessity, we're not going to be able to serve everyone.
And do you have any thoughts about, Al also said that in other states, it's not normally the Department of Corrections that administers such a program. Do you have any thoughts about the Department of Corrections in particular administering a pretrial program?
Yes.
And what might they be?
In Vermont, the way our structure is, that's the place that the legislature saw that it was most appropriate to have it fit into, and that's what the statutory scheme was. The state of Illinois Supreme Court just created an entire pretrial system for pretrial services in 2021. And some counties were doing it on their own. In some jurisdictions, they do things on their own, each by, as was mentioned, county to county. We don't have a state where that type of structure has been historically something that worked. And so right now, it would seem that if you're looking for an organization that is part of supervision, the structure would be the Department of Corrections, because they are supervising individuals. Yes, it's currently after conviction, but this kind of transition, it's a more natural fit. We don't have a resource like that in the judiciary for that type of supervision that would be able to address that.
Thank you.
So I have some more questions, Jenny, and then Martin.
So when you brought up the 912, that struck a note about geographic equity. We have 600 and something $1,000 to invest in a statewide program. Then the question arises, do we cover all of Essex, Orleans, and Newport? We cover all of that first and then move to the rest of the state? Or does this committee make a decision about having something happen in each county before we use up all the dollars? You know, so how is that? I think that's a committee decision about how quickly and how far and where to move. Because the 912 is a big number, and I'm sure there's a big number wherever we look in the state.
You will. For instance, there are 12,375 current violation of condition cases pending in the state today.
Cool.
So if I can interject here a little bit and shift to corrections in terms of testimony that was given on what the real cost of this would be if it was rolled out to all areas of the state. It's a lot more than 640,000.
Yeah, so
Commissioner or
Yeah.
Al,
we
just identify
testified in the
yourself.
legislature last session that in order to, in our estimation, in order to effectively run a statewide program, you would require 14 additional staff beyond what we have right now. I think the revised estimates on cost there is that's about $3.5 million. So you figure each position that we add is about $150,000.
100 what?
150 when you factor in salary, fringe, and benefits. In addition to the electronic monitoring equipment, any equipment officers need, any other programs that we roll out, subscriptions to services that we have. And we offered that up to the legislature last year. The legislature said, well, we'll give you 5 positions and $600,000. That's not a pool of resources that we can effectively run a state.
And that's why.
So we haven't decided that we only want to run it in Newport. We decided we only have the resources to run it in one jurisdiction.
So no, but what you're raising a really interesting point, and this whole program is a program of prevention. So what we're looking at are initial investments, but we're also looking at savings down the road, and savings in terms of court time, savings in terms of theoretically, and savings in terms of community theft and other crimes. So
Potentially.
is there any assessment in other states of what the savings are going forward or the benefits going forward when there's a pretrial program in place?
Well, I think, from our research in setting up these programs, there is not a large body of evidence to support the efficacy of pretrial supervision programs. Not that they're not effective, but that the research isn't really there. And to include in states where they have had pretrial supervision programs for a period of time. I think to Representative Wood's question, the goal is not necessarily to focus on violations, but is to help people navigate the system on the front end. One of the areas that there is a strong body of evidence is simply notifying somebody the day before their court date that they have a court date the next day increases their likelihood to show up. So it's those simple supports and substance use issues, et cetera. If we can start impacting those areas on the front end, we may get higher compliance with the court process, which in turn allows us to move through a greater number of cases, hopefully people off ramp away from the justice system in the long run. Those would be the predicted or hoped for costs avoided later.
But Senator Lyons, if you would like, the individual who heads up the Illinois program they took her from the Cook County Court. Judge LaFavor Smith, who I actually spoke with about pretrial services out there and here in Vermont. And I can follow up with her about that to see what Illinois' experience has been. Can they quantify any savings, whether it's time or finances?
Thank you.
Martin.
Yeah, I just want to explore or make sure there's an understanding of who may be channeling into this. You mentioned a whole lot of conditions of release violations. And then the individuals who have about the dockets, I think there's 33 total individuals thereabouts.
That was my
So-
counting sitting over here.
Yeah, so all those 33 individuals aren't automatically going to go into this. That has to be, the state's attorney will probably exercise some discretion. We'll be working with the defender to see who is appropriate for this. That's actually, in fact, where some of the geographic inequities come in, because different states' attorneys may approach this somewhat differently. But we wanted to have it fairly broad as far as the initial pool of people who could be eligible, but relying on the state's attorney and then that's DOC process to weed it out to the people who really need this or will benefit from this. I mean, I don't mean to be testifying. I'll make that into a question. Is that true? What I just said?
That there would be an effort to identify who is going to benefit the most?
Right.
Absolutely.
Right. So I did have, if an individual is referred to DOC and they do the risk assessment, is it true that if this is a non-violent misdemeanor of low risk, that might not be the person to put into this, the supervision program?
The court's going to have to assess each individual case as it comes in, but if you have the state and the defense bar saying, well, Judge, we know we only have 12 slots and here's 15 people and here's how we look at them, the court will certainly consider those factors in deciding how to place someone into the program with limited availability.
Can I ask one question that's a little bit off topic, but since I have Judge Zona here and I'm looking at the risk assessment. So.
I'll provide you a little.
All right, just a little. So if the DOC is conducting this risk assessment and finds that there's a P3, the highest level, is that something that the court does or can take into account for setting priorities as far as when to get to that case, when to schedule that case for trial?
Since this is not something which is in practice at this time,
Okay.
it's not something that we would have done. In other words, this process doesn't exist, so we wouldn't have been faced with that.
Right.
I suspect the court could potentially take that into account, but it's not something that we would normally have in front of us. And so.
Right, this will be new.
It would be something new to consider.
So if you could flag that, put it on your, to monitor that, because that could be helpful for setting priorities to get cases through. Thanks. Thank you for the leeway.
Yeah, you owe me one. So I have a couple of questions. Would the court also be looking for placing a defendant on this program if there is a risk of non-appearance or a risk to public safety or flight? Would they also take that into consideration?
Yes, those are factors the court would need to consider when determining under the statute whether or not someone's going to be placed into the program.
So it's more than just a violation of current conditions or that they have 5 or more dockets.
Right. The statute sets forth criteria that the court would have to assess, and those factors are included.
So my other question is, in terms of the policies and procedures that DOC put out, in terms of having the probation PMP officer being named as party to the case, does that raise any flags? Does that work for you folks? Is there any concern there?
It's already done. For instance, this morning, if we look right now at the Orleans County criminal docket, many cases have a probation officer who was already listed in the docket sheet. I haven't been able to confirm yet whether or not that means they're getting notice of every hearing, but I believe that means they get notice of the hearing. The one question, so as far as being able to add a probation officer, it's generally done at the end of the case if there's a violation of probation, as Mr. Cormier said. If this program goes forward, the question would be for trial court operations, is there an identifier that can be put in such that the probation office for the supervisor is put in immediately, he or she would be added. I know Terry Porsones mentioned a few minutes ago that if we did that, it would make sense that they be using the name supervisor, like supervision, pretrial supervision, as opposed to just probation officer. Because what is the legislature going to want to know in the future? You're going to want to know how many people have been put on it and is there a way to assess it? So Terry's idea was we need to make sure that there's a different name there possibly to identify it for data generation in the future.
Other questions of the Jay? You're off the hook.
And I do have to, I would be remiss if I did not comment on one thing. I know Chair Emmons, you ask about all the time. My understanding is that last week there was a judicial referral to home detention.
How many folks are now on home detention?
As of this morning, the number is still 5. But again, that's a factor of a number of things, but I did want to let you know that a judge did, I'm aware, make a referral last week on it.
I want to offer time to the Defender General in case you want to weigh in on anything at all on this.
Sometimes I wonder if it's in anybody's interest. But
Why not
I think I should.
identify yourself for the record, please?
Didn't, but I'm Matt Valerio, I'm the Defender General. The thing, this is the first time I've seen this internal document that was floated around. The defense bar was not part of the discussion in developing this. And the thing that I'm struck by, just at first glance, and I haven't sat down and gone through it line by line, but one of the things Al Cormier said is that this is pretty much the same kind of intake that we do when we're doing a probation intake. This is very different. One of the things that you have to remember is that every person who's coming in at this level is innocent as a matter of law. And as in that, given that, they have certain rights to not provide information against themselves, to not testify against themselves, to not sign releases, to not, conditions of release typically say to you, do certain things so that we ensure that you are not going to run away. Do certain things to make sure that you are going to show up in court. Keep in contact with certain people so we know how to get a hold of you so that you won't run away and that you will show up in court. And we haven't changed the Constitution with regard to that. So when we're talking about compliance, when it comes to like probation, how many people don't sign releases? Well, they've been convicted already. So there's no question that the vast majority of them, probably almost none, would refuse to sign, releases for treatment and the like that may end up in a violation of their probation that would put them in jail. In these circumstances, I can envision many situations where defense counsel would advise their client to not sign that release. And perhaps other things that are kind of typical of probation that would be contrary to the best interest of defending the charges that are against them. So I believe that pretrial services can be a really effective tool for people who are amenable to it and whose charges are such that it can all work to a positive resolution of what's going on. However, the thing that everybody has to remember, and this is why I have a little bit of concern with existing probation officers being the people coming in to implement the new program, is they're going to come at it, in my estimation, as they come at their probation cases, which is, you violate your probation, I can have you arrested, I can put you in jail, or if you're on parole, I can yank you in like immediately, and you're going to have a, discussion with the parole board about it. This is a different ballgame because the people have not been convicted of what they're on conditions for. They're put there for particular reasons, or they have, and these are the ones who are going to be most successful. They're there because they have agreed
to be part of this program because their lawyer and themselves jointly see a benefit to being able to access resources and the like going forward. Now, remember, and you'll see the same thing in our side, that violation of conditions of release are the number one thing that we deal with. The reason we have violation of conditions of release is we have a massive backlog and existing people sitting on a docket for years and years and years, who over a period of time, eventually people are going to violate the conditions of release. And that's without people specifically watching them. The more people you have watching, the more people you are going to find doing things. And, you know, right now, when we're talking about, and I would, if I were Commissioner Demo, and I was talking about.
The seat is yours.
Oh, I'm not gonna go there. But if I were trying to calculate costs of this, you have to think of the $100,000 a year bed that the Department of Corrections has. I'm using round numbers. I know it's high 90s at this point. Of the people who will violate, who are being watched now, who weren't being watched before. I'm not saying they shouldn't necessarily be violated. I'm just saying the more you watch, the more you catch, and the more people are going to fill jail cells. So when you're talking about cost avoidance, you have to make sure that you're targeting it at the people who are the most dangerous, the high risk, high need, danger to the public people, not the repeat offense property crime people who have 25 dockets. And I know when this was coming forward, the most annoying people were the low risk, high annoyance, 50 count people on Church Street, who is what drove this, So I'll be interested to see how this rolls out. I've had a fair amount of success budgeting in the state for the last 25 years. And if I were going to be budgeting on this, the estimation that I did this last year, just trying to figure out, well, what if we did this? What if somehow they put this in the Defender General's office? The number I came up was twice what the Department of Corrections came up with that they told you about today. Because I would be thinking about those collateral costs that would result from violations going forward, where people are not, right now you're not catching people doing certain things, and they're going to be, we're creating opportunities to do violations with things like, with requirements under the pretrial supervision program. The biggest thing we can do to get violation of conditions of release down is to get rid of the backlog. That is thing number one. This is going to potentially make incremental change in that. But my estimation is, if you're talking about cost, there needs to be a cost benefit analysis. And I think that doing the pilot is going to be one of the ways we make that determination. Everybody knew that $600,000 wasn't going to cover, it wouldn't cover, 25% of Chittenden County. Forget about the state. So the only reason I wanted to talk about this is because I wouldn't want anybody to go into this with rose-colored glasses thinking, now we're providing this opportunity for folks to all get well. And even if we're if you're 50% successful, it would be the most wildly successful thing, that the legislature has created in the last 20 years. But, if you make 10% of the people go away, it would still be very, as a help 10%, that's still going to be very, very successful. So don't look at it in terms of only 10% of the people benefited. When this comes back, when you get this result and you see, only 10% of the people were successful in this, that's going to be a huge win, I think, if you get there. And it's going to cost a fair amount more money than you know, I mean, everybody knew the 600,000 wasn't gonna do it, but I think that the numbers are way out of whack. You know, other states do this a little bit differently. Illinois, I don't like to, you know, Cook County in Illinois is not maybe the best place to compare to Vermont. There are a lot of differences in the way but they did create a pretrial services program, which is good. Massachusetts has, where I practiced before I came to Vermont. Now, granted, it was 35 years ago, but still a long time ago. They attached their probation department to the court, not to the Department of Corrections. So when they have pretrial, their attempts at pretrial supervision run directly to it all. It's really like contempt because it's all based, it's run through the court and it's by court order. You know, so the people who are complaining, there's some weirdness about the kind of the prosecutor, the probation officer, parole officer, and the court working in the same place, but that's a whole other thing. You know, everybody does things differently. But, you know, their success hasn't been great, but there are a lot of differences down there too. All I'm saying is this is a really new thing for Vermont. Years ago, myself, P.J. Donovan, when he was state's attorney in Chittenden County, and Andy Polito signed on to get a grant from Senator Leahy that basically created a Chittenden County style pretrial services program that I'm not sure what the data, PJ at the time indicated that it was very, very successful for the people who took advantage of it, and it was voluntary. I don't know how successful, I never really saw any data on it, but I have no reason to believe that it didn't have some positive impact. And that was about $250,000 that we had at the time to make it work. And it was one case manager who did the screening, who he hired away from my office, was a lawyer from my office. And they had one law enforcement person, I think, who used to be state police or used to be a state police. But anyway, they, and, you know, there was indications that it could be successful. So I have the belief that this has the potential to do the right kinds of things for the people who are voluntary, are amenable to it. People who are ordered into it, you're going to run into some issues as far as like the legality of what they might be ordered to do before they're ever convicted of something. And I wanted to make sure that when we come back later, that somebody told you about that before it ever started.
Appreciate that, Matt. Thank you.
Okay.
Questions? Matt?
All right, thank you.
Thank you. So I know we're running over and we anticipated this would happen. I know that at 11:30, we wanted some updates from DOC. But we really need to figure out as a committee how we want to move forward here with the recommendations that to give on the rollout of this pretrial supervision program. So would folks be willing to go into about 12:15, 12:30, and then take a short lunch? 12:15 is what we'll shoot for. I may have to go over a little. But yeah,
So
so,
I've got a meeting scheduled, so
yeah.
whatever.
Where are we as a committee in terms of the rollout recommendations? We need to be a part of this decision, not just these. So that part of the thinking is the legislature can't come back and blame DOC for not doing its work. We're at the table too. Mark?
I mean, I think lies where they're starting, but I would like to see the rollout plan. Rather than wait to see how the pilot works to then plan, let's wait to see how the pilot works and then we can pull back. But I'd rather have the assumption is that they're rolling to the next county in a certain period of time, et cetera.
Go for it.
I know I'm not on the committee, so take my feedback for what it's worth. I mean, I hear that, Representative, and I agree with you that structured roll-up plans are usually the best way forward, and I think we can support that from a documentation, design standpoint. But realistically, with the resources that are allocated to this program presently, we could maybe roll this program into 2 counties.
Right.
2 different district offices, and beyond that, we're then kind of at capacity.
Yeah, no, and I was suggesting as part of that, that there's an explanation of what the resources are going to be needed for step 3 or whatever, in step 4, et cetera. So that we can start understanding what that's going to look like.
So this is a statewide program, and I think I'm agreeing with Representative Lalonde that we should see what it would be like to have a statewide program. Resources aside, I mean, obviously the ask for resources will come through the budget, and then decisions will be made through the appropriations process. But it is in statute to have a statewide program. It's not a pilot. And I'm thinking about another bill that we passed into law this year where we asked for a statewide program, but we also pulled back and said, let's just do it in one area first. So that's happening, but the guidelines that are being written for that other program are statewide. So if you say supervisor, that's the new term, pretrial supervisor. And that the goal is to make sure that folks meet their court dates and that they understand their responsibilities with respect to their pretrial services program, whatever they're in. So I'm agreeing with Representative Lalonde. I think we should ask for that full explication of full policy. And then to ensure that all the things that we heard from the judiciary and somewhat of what we heard from the Defender General, that this is not a punitive program. This is a program to help people get through a process. We know there'll be resistance, but so be it. So I won't say any more, but I did give suggestions earlier, and I'll let the rest go.
So what I'm hearing, we've got two pieces to this. First off, do we give the okay to do the first part of the rollout up in Essex and Orleans County, based in the Newport field office? Do we approve that? Would we make that recommendation?
Do you need a motion for that? Or
I'm,
just raise our hands.
I think just raise your hand.
I'm okay with that, as long as what you're talking about happens.
The rollout. I think that's the next piece that I'm seeing. Sort of have to get it started because we have to make a recommendation by September 1st. So DOC has proposed that they would roll it out. The first place they would do it would be within their P&P office up in Newport. So
As part of the statewide program.
it's part of the statewide program, limited funding, 600,000, 5 positions. The positions have been allocated, but they haven't come online.
Did we hear that all those positions were needed in Newport?
No, they're not. They're
We
gonna
did
do
not.
one.
Nor could we afford
Right.
the 6 million.
Okay, so what
We
we're
could
hearing
afford a
is,
couple.
Yeah.
And whatever it is, 1 or 2 of those 5 would be used for that. But
yeah,
with a plan
going forward.
going forward for the rest of the state.
How many staff would you need for the Newport? 1?
Well, we proposed, when we testified to this last session, we proposed 1 pretrial supervision officer for the district office, so that's 12, and 2 administrative staff to support the statewide system. So 14.
So I'm okay with relying upon the department's recommendation for where they think that this can sort of, best be started. I'm not as in line, I guess, with the previous 2 comments. I mean, I think we need a rollout plan. But I also think that we should wait for some data before allocating for, it'll be through the budget process. I get that, but I think we should wait for some time and data before we just automatically assume that this is the way we should allocate the limited resources that we have. So, and I'm not sure that we will have that for FY 26.
We might get something from Illinois, as Judge Zoney had.
Right.
Yes.
Right.
Pat, yeah.
There may be other places to get data and make some comparative information. So yes, in terms of relying on their recommendation for the Newport office, yeah. And I guess I'm a little unclear about how the resources would be used, because if we're not at a statewide program yet, why would we need 2 administrative staff out of that 5 to 6 positions? We wouldn't. Yeah, that
That
would
was
be
part
like,
of the state, if we were able to launch the statewide system, resourced per our recommendation for how you resource the entire program, it would require administrative staff. At this stage, we likely would only hire 1 staff member and use the balance of that money to electronic monitoring equipment, any other program costs. And there'd probably be a balance left over that we could roll into the broader program when that came on.
So how I'm seeing this is we can give our recommendation to, yes, take the first step, go with the Newport proposal. But we want to see DOC back at our next meeting with maybe some parameters, some thoughts on what the rollout would look like going forward.
Statewide.
And that we continue to work on that between now and the end of the year. Because it's going to be a process. It's going to be a process. And I think also what needs to be at the table, people need to be realistic in terms of what the cost is going to be. I think that's one of the big pieces. And somehow we may have to work in how are we going to measure the outcomes of this? So we're just not funding a new program, but we don't know if it's being effective.
I guess that was my point.
Is there anything in the statute that talks about data collection and
No, I
analysis?
don't believe
Yeah,
it's
so that's a missing piece.
And Chairman, if I may too, November 1st may be a good target date, since that's when the recommendations have to go to the General Assembly.
And then policies and procedures need to be in place. So that's why I'm thinking the next meeting, which is in September, and then we'll have a meeting in October. That's what I was thinking. Nodder, your hands up?
Thank you. So I'm supportive of the initial rollout. I'm also supportive of at least providing the green light for the statewide rollout, because I don't know that there would necessarily be anything to prohibit us from, if we were to get information from DOC after the pilot program, I don't think there would be anything that would prohibit us from saying, we've learned about such and such factors. We actually have to put a pause on the green light that we previously gave for the statewide program so that we can make some changes. I'm just trying to think of a way to make it so that there's less that there's less hurdles down the road in getting a statewide program going.
So I think for clarity, I think it would be very helpful if we had a motion on the table for this. Because I know as the time goes by, we look back and say, well, what did the committee really mean? So I think it's really important that we do have a motion and that we vote on the motion.
Before you do them, fine.
Bill?
Thank you, Madam Chair. I just wanted to say my skepticism about this program always attached to the money. Senator Sears was a big proponent and he wanted a statewide program. The money was not there. And so we went in a kind of half fashion with the 600 plus, but with a commitment statewide. So I just wanted to underline what Senator Hashim said about the possibility that we pause down the road or even don't move the program statewide down the road, because the testimony, as I understood it, was that the number one thing we could do would be to reduce the backlog. And we put big resources into that last time out, new judges, new resources for all the involved parties. But it wasn't enough, and it's not enough going forward. We're going to be asked again to up all of those numbers. So I continue to have a certain amount of skepticism, fueled in part by numbers like those Matt was roughing out for us. So with that said, I think the committee's adopting a very cautious approach. That's good. The department has offered a cautious approach. So I support the caution and just wanted to underline that with regard to what's going to come due in the budget.
Madam Chair, I think part of the rollout has to have some kind of an evaluation component as part of the rollout too. And that I think supports what set up here. That's being in the red light there, because if it's not working the way we think, then we're gonna stop it. So I think part of that rollout has to have some kind of a evaluation component. Maybe some of that money that is not being used for staff could be used for that.
So why don't we make a motion
Make
that
sure it's written down.
a rough that supports the initial program in Newport, in the Newport area as presented by the Department of Corrections with some slight modifications. We've made a few suggestions. And that the Department of Corrections put forward a plan for a broader geographic rollout of the program with an understanding that two things happen. One, that the legislature is recommended to put in place a data collection analytic process, analysis may end up being two motions, but having an analysis in place. And two, that we continue to gather data as the program goes forward so that prior to any further expansion of the program, the legislature has an opportunity to analyze the results. So that was a long motion, but there are components of it. Ben has it. I know.
Let him finish it, and then read it back to us.
Well, it might be more than one motion, but it's all the things that we
Well, it's
just
all
heard about.
interconnected.
Yeah.
So basically, we accept their proposal. We want them to come back with a rollout plan, how that's gonna be structured. That's gonna take some time, over a couple meetings, and also the evaluation of how the program is going to be.
That will determine further implementation.
Right. And then we can determine if we continue to move forward.
If there's
So
money
Ben,
there.
you wanna reread it? And I'll
So
read
the motion, to paraphrase a little bit,
Good.
is kind of twofold. Sarah Lyons moves to support the initial rollout of the program in Newport as recommended by the department. And two, prior to the statewide rollout, this committee recommends that the department engage in data collection and analysis for the General Assembly to review prior to the full state rollout.
So in that, will there be, I think we would like to see a plan for the statewide rollout, so that we can understand what it is we're,
So what you read as number 2 should be number 3,
yeah.
and a number 2 that is requiring
They come back.
Yeah.
with a plan for the total rollout.
Number 4 is where's the,
well, that's you and.
I mean, that's a lot of work, and we got more meetings.
Break this down to.
Yeah.
I had a quick question on the verbiage, when you said that this committee recommends the department. I would think that we want to require the department to come back with those statistics for us versus recommend. I don't mean have to do it.
So let's break that down into two motions. Let's take care of the Newport and the rollout in the first motion. So
You mean the rollout plan?
the rollout plan.
plan,
Yeah.
plans can always change.
So what have you got written?
So for that one, move that the committee supports the initial program in Newport as recommended by the department, and that the department be required to submit a statewide rollout plan to the committee by
January 1st?
What's the November date?
November 1st is their policies and procedures need to be in place for the,
and it's also your recommendations to the General Assembly on.
could we do November 1st? That would give us a couple, now it's 9, so put November 1st, by November 1st. So,
And do we want to put anything in there about any recommendations for legislative improvements, like for example, the data collection piece or that kind of thing?
so the first motion that Ginny made, not Trish, Ginny made, is that we recommend that DOC, it's the first stage of the rollout, does Newport. And then by November 1st, they would come back to us for proposals on how to roll this out statewide. That's the first motion. There is a second to that.
Second.
Moved and seconded. Bill, Blue seconded. Any further discussion? If not, all those in favor say aye.
Aye.
All those opposed? So it was unanimous. Now, the second motion is pertaining to the evaluation and data collection. And why don't you read what Jenny put out, what words nothing?
That this committee recommends that the department implement data collection and analysis so that the General Assembly has an opportunity to analyze it prior to the full state rollout.
So we want to include data collection from other states. So the department in collaboration with the
Other
courts,
partners.
yeah, others. Look at programs in other states and any data available as the program in Vermont rolls out, because that's not going to happen for a while.
Right.
Other states probably more important.
And
And I'm looking at Judge Zone.
I think we need to have the word require rather than recommend.
Oh,
Or shall require, shall.
got it. Probably got it.
Would you pick that up? So the evaluation and data collection would happen over time. Yeah, there's no date to that. It's over time.
Yeah, except Madam Chair, we're not going to continue implementing the rollout plan unless we've got information that's positive. Saying,
We
sure.
have to have those positions allocated, I mean, online, and those positions are online. Can't even get the Newport one going, the position comes online.
So what I have is that DOC is required in consultation with others to examine programs in other states and any available data on the efficacy of similar programs, so the General Assembly can review the data prior to the statewide rollout of implementation.
Works for me.
So you moved, Ginny.
Yes, I know that.
Is there a second?
It works for me.
Bob wants a second.
I'll
Okay,
make that motion.
okay, pretty for me.
Oh, sorry.
Already been made.
The committee
For the
meets.
committee. So I'm not gonna have Ben reread it. It's basically do an evaluation, come back with it. Any further discussion? If not, all those in favor of the motion, please signify by saying aye.
I
All those opposed? That was none. Who is the second? Senator Norris. We knew that was gonna take some time. This is gonna take time. It is 12:15. We do need an update from DOC. I'm willing to push that off until 1 o'clock. If people want to do that. I want to hear about the Medicaid waiver, the 1115 waiver, detainee population, other things. And then we'll go into what's scheduled for the women's facility and also the juvenile facility. So thank you, folks. So we'll be back here at 1 o'clock.